I stand before you to speak about the latest judgment, the Veena Siddhappa versus Malika Arjun and others. This case was decided by a three-judge bench, uh, Chief Justice D Y Chandrachud, Justice J.B. Pardiwala, and Justice Manoj Misra. In this judgment, the Supreme Court held that a child born from void and voidable marriage can claim rights in their parents' ancestral property in the joint Hindu family following the Mitakshara system of law. Children born from void or null marriages are declared legitimate by subsection Clause 1 and Clause 2 of Section 16 grants them rights in their parents' property. This ensures they cannot be discriminated against and are equal to other legitimate children. The benefit of Section 16 Clause 3 is only available when there is a marriage, but the marriage is null. The amendment by Act 68 of 1976 changed the common law view of children of void or voidable marriages, removing the stigma of illegitimacy. The law aims to remove the stigma of illegitimacy faced by children of void or voidable marriages, ensuring equality of status, opportunity, and individual dignity. Presenting the petitioners, Ayush Gangwal and respondent Uday Saxena.
Your Honor, I am the counsel for the petitioner. I argue that children born from void or voidable marriages should be considered legitimate under Section 16, subsection 1 of Hindu Marriage Act 1955. This provision states that if a child of such marriage would have been legitimate and if the marriage had been valid, then they should be declared legitimate.
Can you provide any supporting evidence to strengthen your argument?
Yes, Your Honor. The Honorable Court in the previous judgment in the case of Controller of State Duty Madras versus Alladi Swami analyzed and formulated the 6 essential aspects of Hindu co-partnership. These aspects include: number 1, lineal male descendant up to the 3rd generation acquiring an independent right of ownership by birth. Number 2, the right of co-partners to work out their right by demanding partition. Number 3, ownership extended over the entire property until partition. Number 4, common possession and enjoyment of the property. Number 5, no alienation of the property without co-partners unless for legal necessity. And number 6, the interest of a deceased member lapsing on death and merging in the co-partnery property. These aspects support the argument that children born from void or voidable marriages should be considered legitimate and have rights in co-partnery property.
On the behalf of the respondent, Your Honor, Section 16, subsection 3 of the Hindu Marriage Act deal with limits the right of the children born from void or voidable marriage. This provision states that these children do not have rights in the property of anyone other than their parents. Therefore, their rights should be confined to their parents' property and not exact to ancestral or the co-partnery property.
Is there any additional argument or evidence you would like to present opposing the respondent?
Yes, Your Honor. The amendment made to the Hindu Succession Act over the years reflect the intention to treat all legitimate children equally as co-partners. The 1976 amendment clarified and reinforced the limited scope of inheritance rights under Section 16. This established how legislative actions consistently address potential legal voids, ensuring no gaps in the law concerning the inheritance rights of all legitimate children. Therefore, it is crucial to interpret Section 16, subsection 1 in a manner that uphold the legislative intent of granting legitimacy and co-partnery right to children born from void or voidable marriages.
Can you provide any legal precedents or supporting evidence to strengthen your argument?
Certainly, Your Honor. The amendments made to the Hindu Succession Act, particularly the substitution of Section 6, subsection 3, provide for the devolution of the share of Hindu male co-partner in the property of a Hindu undivided family, governed by Mitakshara Law. The amendment provision states that the devolution shall take place by testamentary or intestate success under the Act and not by survivorship. This indicates that the legislature intended to limit the inheritance right of the children born from void or voidable marriage. to their parents' property and not extend them to ancestral or compulsory property.
Is there any additional argument evidence which you would like to present?
Yes, Your Honor. The nature of property held by a branch or joint Hindu family until partition among the members of the branches does not cease to be that joint family property of all co-partners of branch children governed with the legitimacy under section 16 are not co-partners themselves, but rather part of the branch comprising the father and his children born out of a voidable marriage. Therefore, their rights should be limited to the property partition from the larger conspiracy and not extend to the ancestral and co-partnership property.
Lordship, I want to ask some question to the counsel for respondent.
Permission granted.
Should not illegitimate children be treated equally when it comes to the inheritance right? And is it fair to deny them a share in co-partnership property solely based on their legitimacy status?
As the petitioner asked me, it's essential to uphold the principle of equality in the matter of inheritance, denying illegitimate children's share in conspiracy property based on their legitimacy status, determinants and equality, and children, regardless of their legitimacy, should have equal rights. When it's come inheritance by recognize the property rights of illegitimate children, we can ensure fairness and equal treatment for all individuals regardless of their birth circumstances.
Lordship, can I ask another question?
Yes, you may ask.
While previous cases have recognized the property rights of illegitimate children, do these cases directly apply to the issue of co-partnership property, and should not we consider the specific context and principles governing co-partnership properties right?
While previous case may not directly apply to the issue of conspiracy property, did not establish a legal precedent that recognize the property rights of illegitimate children. The President supports the inclusion of illegitimate children in the distribution of co-partnership property, ensure that they receive their fair share.
While it is true that promoting equality and fairness is important, we must also consider the potential impact of granting illegitimate children a share in co-partnership property. This could lead to conflicts and disputes with families and may undermine the stability and harmony in the family unit. Moreover, it is important to respect established customary practice and traditions that govern the distribution of co-partnership property. These practices may not recognize the rights of illegitimate children, and it is not the court's role to override or interfere with established customs. While it is important to strive for equal rights and opportunities for all individuals, we must also balance this with the need to maintain social harmony and stability with the families and communities.
Your perspective on the interpretation of section 16 subsection 3 is clear.
The Honorable Supreme Court observed the freedom and status of an illegitimate child have consistently been in dispute and no close to home law needs to address it. However, there have been many changes in the Hindu individual law, yet there is an advanced age of thinking for the draft procedure regarding other individual laws to be specific to the Muslim and Christian laws. Hindu law is reforming other two individual laws that are lagging in granting the authenticity status to the illegitimate children, Hindu law. However, reforming isn't at all idle. The situation of an illegitimate child brought into the world to a Shudra was vastly improved when contrasted with the current individual law.
After careful consideration of the arguments presented by the petitioner and the respondent, as well as the relevant legal precedent and legislative intention, this court now delivers its judgment on the interpretation on section 16 on the Hindu Marriage Act 1955. The issue at hand revolves around the legitimacy and inheritance rights of the children born from void or voidable marriages. Section 16, subsection 1 of the Act declares that a child born from such a marriage to be a legitimate if they would have been legitimate had the marriage been valid. However, section 16, clause 3 specifies that these children do not have rights in the property of anyone other than their parents. Upon analyzing the precedents and the legislative amendments, it is evident that there have been different interpretations of Section 16. The court acknowledges that the decision in Genia Cavatin and subsequent case took a narrow view, Section 16, subsection 3, limiting the rights of children born from void or voidable marriages to their parents' property. However, it is important to consider the involving consideration of the public policy and the need to strike the balance between safeguarding the interests of these children and other co-partners. The amendments made to the Hindu Succession Act reflect the intention to treat all legitimate children equally as the co-partners, thereby recognizing their rights to the property. In the light of these considerations, this court holds that children born from void or voidable marriage declared legitimate under Section 16, subsection 1, shall have right in ancestral or co-personary property. The limited scope of inheritance rights under Section 16, subsection 3, shall be expanded to ensure quality and fairness among all legitimate children. Therefore, this court declares that children born from void or voidable marriage who are deemed legitimate under Section 16, subsection 1 of the Hindu Marriage Act shall have equal rights as co-partners in ancestral or co-personary property. This interpretation aligns with the legislative intent of promoting gender equality and ensuring equal rights for all children. This judgment aims to rectify the discrimination faced by children born from void or voidable marriage and uphold the principle of justice and fairness. It is in line with evolving societal norms and need to protect the rights of all individuals regardless of validity of their parental marriage. With this judgment, the court hopes to provide clarity on interpretation of Section 16 and ensure the rights of children born from void or voidable marriage are upheld in accordance with the principle of equality and justice.